Hello, my name is Brian Sipneski, and I'm a case manager with the Kent County Friend of the Court. The purpose of this video is to provide you with some basic information about custody, parenting time, and Friend of the Court services. First, we are going to speak about custody. There are two components to custody: legal custody and physical custody. Legal custody involves the decision-making on issues such as religion, schooling, medical, and counseling. If you and the other parent share joint legal custody, you are expected to make these decisions together. You must consult with one another before making a decision. However, if a parent has sole legal custody, that parent can make these decisions on his or her own. Now, physical custody refers to where the children live most of the time. If a parent has sole physical custody, that means the children live primarily with that parent. However, if the parents share joint physical custody, each parent shares a good deal of time with the children, but it does not have to be 50-50. It could be 60-40 or some other variation similar to that. Now, if the case is split custody, this occurs when one or more of the children live with one parent and one or more of the children live with the other parent. And finally, there is third-party physical custody, and this arises in cases when the children live with neither parent. The children could be in a foster care unit or with a guardian. Now, it is important to remember that children typically do best when they have time with both parents. However, situations do arise to where it is not in the best interest of the children to be in certain environments. If a situation arises that is alarming, it is important to change your court order to address the new situation. Well, why is it important to change your court order? Because the friend of the court can only enforce court orders. That's what's in black and white. So let's talk about friend of the court enforcement in greater detail. The friend of the court can enforce your court orders involving physical custody, parenting time, and, as you already know, child support. The friend of the court can only enforce what is in the most recent or current court order. The friend of the court cannot enforce agreements between the parents, even if these agreements are written and notarized. Therefore, all agreements must be in a court order. Here's an example. If your parenting time agreement states alternating Fridays at 5 p.m. through Sunday at 5 p.m., but you and the other parent have agreed to Thursdays at 5 p.m. through Sundays at 5 p.m., and have done that for approximately 6 months, and parent A says to parent B, no more Thursdays, and parent B contacts the friend of the court and says, we've been doing this for 6 months, it's not in a court order, and the friend of the court cannot enforce the parent's agreement. Now, many of you have cases with a suffix DP or DS, and these suffixes are located in your case number. Oftentimes, these orders are very general in regards to parenting time and state parenting time as agreed by the parties. Well, if you don't agree, the friend of the court has nothing to enforce because the order is very general and states as agreed by the parties. Therefore, it is recommended that you get a specific parenting time schedule in writing. Please remember, the more specific the order is, the more enforceable it is. In order for the friend of the court to help enforce your order, you must follow it. You must follow it as closely as you can. Now, this includes making a physical attempt to get the children when and where you are ordered to. So, for example, if parent A says to parent B, you cannot have parenting time tonight, parent B must still make a physical effort to pick the child up for his or her parenting time for there to be an enforceable violation. So if parent A says by phone, you cannot have parenting time tonight, that is not an enforceable violation. Parent B must make that physical attempt to pick up the child for there to be an enforceable violation. Now, if you feel that the other parent denied your time with the children, you may file a complaint in writing with the friend of the court within 56 days of the violation. The other parent then has 21 days to respond to the written complaint, and once that answer is received, the friend of the court staff will review all the documents and decide which action to take. These actions may include a settlement conference, a co-parent session at the friend of the court, make-up parenting time, no action, or refer it for a court hearing. If a court hearing occurs, it is up to the judge or referee to determine which remedy, if any, is appropriate, which could include fines and/or costs. So what can't the friend of the court do? The friend of the court cannot enforce agreements that are not in the court order. You already know this, we've gone over this. The friend of the court also cannot enforce violations dealing with legal custody. You may recall legal custody addresses the decisions parents make regarding health, education, counseling, and so forth. Now, if there is a violation of legal custody, either parent will have to file a motion and present that violation to a judge for a determination. It is important to know that children cannot decide whether or not to participate in parenting time. If there is an order in place, each parent is expected to make sure that it is followed. If you feel the parenting time or custody order no longer meets the needs of the children, it is your responsibility to have that order modified. Remember, it takes a court order to change a court order. It is also important to keep in mind that parenting time and child support are separate issues. If a parent does not pay child support, he or she is still entitled to time with the children. However, if a parent does not see the children, it does not excuse that parent from paying child support. Now let's talk about modifications of a court order. There are a couple different ways to change your parenting time or custody order. First, if you and the other parent may be able to reach an agreement as to custody or parenting time, either parent may request mediation. To request mediation, either parent simply needs to write into the friend of the court and request that mediation in writing. Mediation is voluntary, confidential, and that there is no cost to either party. Parents are not required to participate in mediation. They must agree to mediation for it to occur. Now, if they agree to mediation and attend, and no agreement is reached during that mediation, no recommendation will be made by the friend of the court. However, if mediation is successful, a recommendation will be made by the friend of the court, and a subsequent order will be completed and enforced. If mediation is not successful, or you and the other parent do not agree to attend a mediation, a motion must be filed to change custody and/or parenting time. Now, you may file that motion on your own or with the assistance of an attorney. Motions are filed at the circuit court, and there is typically a $100 filing fee. If you do not have an attorney, the Legal Assistance Center, located on the 5th floor at the courthouse, can assist you with filling out the appropriate forms. However, they cannot provide legal advice. If a motion is filed with the circuit court clerk's office, the result will be either a scheduleless hearing, the issue could be referred to friend of the court for an investigation and/or a recommendation, or the motion could be dismissed, which usually occurs if a legal standard is not met by the information provided in that motion. Now, if you are referred back to the friend of the court for an investigation or for a troubleshooting, The court may require one or both parties to pay a fee, but that is at the discretion of the judge. Now, during an investigation or a troubleshooting, you will meet with an FOC evaluator here at the front of the court. The evaluator will review the information available and make a recommendation to the court regarding custody or parenting time. Therefore, make sure you bring any documentation you feel is relevant or important to that interview, along with additional copies for the evaluator. You now have some basic information about custody, parenting time in front of the court services. If you have any further questions regarding any of these topics, you may wish to contact an attorney, or please feel free to contact your case manager. Thank you for your time.